Pasadena.
Good morning. I'm Adam Richardson. I represent the petitioner and plaintiff. Next to me is Nicole Ziegler, who is co-counsel in the trial court.
I didn't hear you. Did you reserve 5 or not?
That was the next item on my list, sir.
Okay.
5 minutes, please.
All right.
Right. So the first thing I want to get out of the way is, in reviewing this case for preparation today, I did notice I think we have a preservation issue with the Sunshine and Litigation Act argument we make because it hasn't been resolved yet in the trial court. So I'm going to set that aside for the purposes of today, and we may decide to pursue it in the trial court, perhaps come back here at some point. So this is unusual. This is the first OA I've had in an original proceeding case. And I think the court probably has a lot of questions it wants to ask of us, but there's one or two things that I wanted to emphasize more clearly than they were in the briefing, I believe. The first is the effect of Florida Waterman versus Buster, the Florida Supreme Court case from 2008. Our position, sorry, am I not speaking?
Yeah, just get closer to the mic.
Is that okay?
Yeah, we have the same problem. So if you can't hear us, tell us the same thing.
Okay, so I wanted to make our position more clear than it was in the briefing about the effect of Buster, the 2008 Florida Supreme Court case, on the issue here. So our position is that Buster actually controls the case, that it's dispositive on the merits.
Yeah, but aren't those cases all about a denial of production?
Yes, they're about the denial of production.
That didn't happen here.
That's correct. But what Buster stands for is that certain certain statutory provisions are unconstitutional as a violation of Amendment 7. And the court was a little bit broader than production in Buster. So the statute that the court was reviewing was 381.028. And that was the so-called implementing statute for Amendment 7 that the legislature passed. But it wasn't just about access. It was actually a very broad statute. And it included restrictions on the use of records. In fact, one of the subsections, 6, was labeled use of records. And in there, it talks about, specifically in subsection B, are not discoverable or admissible into evidence and may not be used for any purpose, including impeachment. And this was one of the subsections that the Supreme Court in Buster specifically invalidated. And
but here, the request is being made that the court enter an order allowing you to disseminate it to the experts for use in depositions, correct?
yes, ma'am.
Okay, and the statute is silent though as to who, once access is provided to that, where that goes from there. And so wasn't the court having a dilemma? I mean, I think the words were practical. This is a practical dilemma or something like that, because there's also the statutes that talk about this evidence is inadmissible. And so if the court enters an order allowing it to be used in deposition, then later on, there's this risk that expert testimony is going to be excluded because they're relying on inadmissible evidence. I mean, isn't that the practical consideration that the court, so the court, in essence, at the end, just said, I'm not going to enter the order that you want me to enter. And so how is that irreparable harm here for our cert jurisdiction?
Because, I'm sorry, the effect of the order is still to interfere, deny, or delay the application of a constitutional right in this case.
Where's the constitutional right for the request that was made in the motion to the trial court?
The constitutional right is Amendment 7, which was discussed.
Access repeatedly in all the case law talks about that. That's for access to the records.
Yes, and at that point, we disagree with the 5th District in Bartoway and the 6th District in Regala specifically, which is where...
But those are inadmissibility cases. Are they not?
They're inadmissibility cases? Well, no. Bartoway is an admissibility case, and Regala was an interrogatories case. So that didn't concern admissibility directly. But the reasoning in Bartoway could be applied even to use in
Well,
litigation.
mentioned use, but use wasn't really, use or admissibility, and the court talked about use, but the only real use involved was admissibility.
In which case, Matt? Yes, yes. I think that's one of the points we make in the briefing is that it is factually distinguishable, but I still do think that the reasoning could be applied fairly.
Yes,
sir.
I'm sorry, Kate.
No.
I think I had your briefs, you already briefed it well. Even if we take your view that I think you want us to take on Regala and Bowdy, which in other words on Bowdy, yeah, it was about admissibility. Regala was, yeah, you can't propound interrogatories specifically about these records, because of the statute. Before we get to all that, I want to understand what you think the trial court did and support it. And because the qualification on the access was imposed by the opposing party, not by the court, right?
Yes.
Right? So what was your client seeking the court to do, and what did the court do or not do that is, as Judge Smith was saying, causing irreparable harm? What restriction did the trial court put on your party's use of the records that contravenes Amendment 7?
Okay, so the first part, what the order actually does. The order forbids my trial counsel from showing the Amendment 7 adverse incident reports.
But is that just the qualification you got? The opposing counsel made the threat, as you call it, which is fine. It's whoever you want to look at it. That's, oh, yeah, look, we're going to disqualify your witnesses, your experts, if we find out you showed it to them. It didn't say like you can't show it. It says, yeah, we don't show it because we'll disqualify them. But
Well, and that's why my trial counsel took the precaution of filing a motion like this to establish.
what did you want the court to do? Say, yes, you can show them to the expert witnesses?
Yes, sir, and then also ask questions of witnesses and depositions about.
Those are two separate things, by the way, just so, I mean, this is a complicated case, but it's also hazy on, and that's a problem for cert, right? On what happened, what was denied, what was granted. So you would agree or not agree that those are two separate things, showing them to the expert and questioning witnesses. If you can't, under Regala, ask interrogatory questions about these records, why should you be able to ask deposition opponents about these records?
Judge Atkinson, I actually agree that those are two separate things. I think that if you follow Regala, we probably wouldn't be able to do the second thing. But even under Regala, we should be able to show them to the experts. Now, I do think that Regala was wrongly decided on that point because it followed the reasoning of the 5th District in Badawi, which said that there was no positive right to use, which is why I keep talking about Badawi because of the reasoning and its implications on.
I mean, aren't you really just asking for a request from the trial court to sanction you being able to give these records to your experts so that later down the road you can introduce the expert testimony that relies on it?
Is that going back to the practical issue a little bit?
No, I'm just saying you're basically asking the court for permission to do something so that later down the road you can argue, well, Judge, you let us, give this information to our experts, so, this is obviously in their opinions.
And it's going to be, to add to that, it's going to be very hard to separate an expert opinion on the standard of care for a doctor without taking this into account, even if they don't articulate that they did.
Well, Judge Morris, I actually don't think that's true. Now, there's a case that the other side relies on where there was a person who was actually a participant in the peer review process of the very incident. I think in that kind of a case, even whatever assurances that expert provided in the affidavit to the trial court, you can't trust that. I get that. But if you have one document, Amendment 7 adverse incident reports, but then you have other medical records on the same incident, you can, I think, as a practical matter, consult with your expert or even ask questions in deposition about it. The way I was thinking about it is, for example, if you're asking your expert to reach an opinion, okay, Dr. So-and-so, here are the medical records in one stack. here's the Amendment 7 adverse incident reports in another. I want you to look at this by itself, tell me what you think, what's your opinion here. After you do that, I want you to look at the adverse incident reports. Does it change, inform, add texture to your opinions or not? And then at a later date, if there's a motion to disqualify or for any other relief, for example, for
I don't think Amendment 7 gives you the right to request the information, and I think that the trial court found that your request was beyond what Amendment 7 was. I don't know that the order precludes you from doing what you do. Obviously, there seems to be a risk from what, the trial court and some of the cases are saying. I guess my next question is, the trial court controls the mode and the mode and presentation of evidence, and also controls discovery. Is this something that was in the trial court's discretion to, on this evidence, to do at this point in time?
No, Judge Smith, because a judge's discretion is controlled by law, here, constitutional amendment, and we see that in evidentiary rulings all the
There has
time.
to be a right, and it's
Yes.
silent as to the request that you're seeking.
Well, and I have two responses to that. First, in Buster, the Supreme Court of Florida expressly invalidated a use restriction in a statute. They've already said that there are rights beyond or implied by access. And so I don't think, and I'll get into Badaway because that's really presented by the Badaway opinion. In there, the Fifth District said there's no possible.
But they also preserved to the trial courts the evidence code, correct?
Yes, ma'am.
Okay.
Okay, but see, that's the problem for another day. So,
Well, that's what I was kind
Yeah.
of contemplating in my mind, did the trial court, I mean, the other part of this is, did the trial court jump the gun
yes,
at this point in time?
yes, Judge Smith, and that's,
And then my only question is this a matter for cert?
I'm going to address that first part first, because I do want to address that directly. The cases that the other side, my colleague cited, I think actually when you read them carefully, are kind of helpful for us because they establish the procedure that we should go through. And specifically, they point to the rule of the evidence code 90.704 that allows experts to rely on inadmissible facts and data, so long as they're reasonably reliable. So even then, when an expert relies on inadmissible data, so long as it's not entirely, the opinion's not entirely based on the admissible facts or
But
data.
in that scenario, what's different in this case is there's a specific statute that says these certain records are inadmissible. I think that's the distinction.
Well, that's right, but the Florida Evidence Code says that a bunch of different things are inadmissible too. For example, subsequent remedial measures or certain kinds of character evidence. But 90.704 provides the way to evaluate opinions that rely in part on that kind of inadmissible data. And I think the fact that these statutes, the 395, 019, and 7, speak in terms of an inadmissibility, tie it very closely to 97.104, which also uses that precise wording. So now, the propriety of cert relief. We've pointed to, I think, 3 cases that we believe support us. One of them is from this court, but the two
Before
other.
we get there, August.
Of
Before we
course.
get there, so, because it's very important, but, and it's working the road, but, let's say that we take Buster to mean you can show it to anybody. Let's say we accept that, we accept your take on the expert testimony based on inadmissible evidence as opposed to Ellie's take, which is, it should speak for itself and it's promoted. Why don't, after this court's order, why don't you just do that? Why don't you just show it to your expert? And why don't you just wait until you say, yep, here's Dr. So-and-so, and then the FLE says, well, no, we want to disqualify Dr. So-and-so, and then it's an issue.
I don't think that those.
Why can't you do that?
The best way I can describe it is I don't think it's mutually exclusive. I don't think the fact that we can seek cert relief at that point means we can't seek it now. But I understand that goes back to,
Irreparable harm,
Yeah.
yes,
irreparable harm that persists through the duration of the proceedings and cannot be remedied on direct appeal. Seems like maybe you can't remedy on direct appeal, but it seems like we just talked about another instance where it might not persist throughout the proceedings if you get a favorable ruling on whether, having shown these records to an expert, that expert can testify even if partially based on invisible evidence.
right, but I think this gets back to what the court did. And so I think respectfully, I don't think there really should be any confusion about that. The court said in paragraph 2, 8224 in our appendix, the court finds there is no authority to support any right to disseminate records produced pursuant to Amendment 7 of the use in a civil action, and that in order allowing such dissemination in this civil action would create new law that would be problematic. And a necessary implication of that is we're just not allowed to do it. We can't disseminate it. We can't show it to our experts.
You said that was on page, what, 224 of the?
224.
The court's order.
Yes, 224.
You said,
It's paragraph 2.
sorry, okay, the court finds there's no authority to support any right to disseminate records produced for use in civil trial, and that in order allowing such dissemination would create new law. Okay. So you're saying, you take from that, the trial court, it's almost like you, have you ever heard of the adage, better to beg forgiveness than to ask permission? It almost sounds like you ask
Absolutely.
permission
Yeah.
prematurely, but you're saying that still gives you the right to cert because you got an answer
Yes.
that denied it.
Yes, and Judge Atkinson, that's actually one of my favorite adages, and one to live by, I think. But yes, I think that, in an abundance of caution, trial counsel sought a ruling earlier rather than later to avoid some of these other problems. And what we got was a clear ruling from the trial court stating that we're not allowed to disseminate these records to our experts, among other things, like the second separate thing that we were talking about earlier.
See, I have a problem with whether this is a departure from the essential requirements of the law. Because in order for it to meet that standard, you just can't have a difference of opinion on what the law is that the court, ruled on. It's got to be completely, beyond the scope of reasonableness on a legal basis. And we clearly have cases back and forth here about what you can do with these records. So that doesn't qualify as a departure from the essential requirements in my view.
Okay, so I actually think there's an easy response to that. You look at the hierarchy of law. What's the supreme law here? The state of Florida's Constitution. Okay, so we think that is that the interpretation of the Fifth and Sixth
You
Circuit.
got access, which the constitutional provision allows.
Right, the constitutional provision in its narrowest interpretation allows access. I think what's notable to me about the Fifth District's opinion is that it did not conduct a rigorous analysis of the language of the amendment. For example, we now do originalism. So one of the things that we look at are dictionary definitions that are in the Florida Supreme Court's words, error appropriate. And the court didn't do that. Access has different definitions. And
Well, Buster, there's a lot of people take different positions on what Buster did and did not say. But among the positions that are taken is that these incident reports can't be prohibited from being used for any purpose in any civil action. What does that mean? Trial? Or does that mean pretrial? Or both?
not pre-trial, because it does say pre-suit, although I think if, that's a tough one, Judge Morris.
Here's my point though. When we're on cert, we're not really determining we're not here to determine what's the right law here. We're here to determine whether the trial court departed from the essential requirements of the law. In other words, the trial court applied a law that everybody agrees does not apply. We don't have agreement on this. The courts are all over the place on it.
Yes, and that's why I go back to the hierarchy of the law. So the first thing that I wanted to talk about in response to that is something I forgot, but that's okay. Because going to the hierarchy of the law, you have the Constitution, that's what controls. It controls even over contrary judicial opinions, some say. I don't think that's necessarily true. But that's why we go to Buster, because Buster definitely controls over contrary district court opinions. And we interpret Buster perhaps differently than other people, but the court was clear as day, and in Badawi and Regala, neither court discussed Buster and what that implications Buster has for Amendment 7.
You're not only into your rebuttal
Oh, I'm
time,
sorry.
and my zeal to listen to your presentation, I've allowed you to go,
Oh,
use all your rebuttal time. That's my fault. You're gonna get 5 more minutes, and you're gonna get 25 minutes, okay, to be fair.
oh, well, the
My
indulgence is
fault. But It's
appreciated.
an interesting argument, interesting case, and I just got absorbed in it, didn't pay attention to the clock.
Good morning, Your Honors, and may it please the Court. Gavrila Bratz from Ferentino and Bratz on behalf of the respondent, HCA Florida Pasadena Hospital, one of the defendants in the medical malpractice action below. Your Honors, we're here today on a petition for cert, which is trying to change the law. They have put forward an argument that has been rejected by both the 5th and 6th Districts of Appeal, asking the court to interpret a provision of the Florida Constitution to read the term access to mean something quite different, which is use. The same argument.
But aren't there cases out of the 4th DCA that support what he's trying to do?
No, Your Honor. I believe the court might be referring to the Fain decision, which adopted and applied the Florida Hospital versus Buster decision that we've been discussing from the Florida Supreme Court, which solely addressed this right to production of records and the applicability and scope and constitutionality of Amendment 7's implementing statute 381.028. I'm referring to it as Amendment 7. It's Article 10, Section 25 of the Florida Constitution. But that expressly provides, as Your Honors have noted, this constitutional right to access. Access and have access to records is defined in that amendment.
It says, nor does the amendment in any way limit nor could it reasonably limit to whom information could be revealed unless disclosed.
Your Honor, I believe the court is referring to the Amisub Northridge Hospital versus Sinaglia case, which is also from the 4th DCA. I think I misunderstood which case you were referring to. In that case, the court found, when discussing a right of access to production of records, that a patient, which is defined very broadly, a patient has a right to have access to records. They don't have to have a proper purpose as...
Let me ask you this, could a legislature just say, look, this particular type of, of adverse incident report is only allowed to be read by the patient. If that the patient can be somehow sanctioned, or there can attach some sort of criminal or civil liability if you breach the confidentiality. You can't show it to your mom, can't show it to your wife, can't show it to your doctor.
It's an interesting hypothetical, Your Honor.
So that's what's happening here, right? What one way of perceiving this is, and opposing counsel pointed to this paragraph 2, which seems to say, look, no, I can't, the trial court cannot authorize you to disseminate this in the manner you wish to, which is to your experts. And also, of course, let's leave aside the questioning when this is a deposition. But what essentially it sounds like you are trying to justify is a categorical prohibition on a class of individuals to whom this patient who has a right of access to these records cannot reveal this information.
No, Your Honor. There's one distinction. There is a prohibition on showing these records to experts in litigation so that they can base their opinions upon them, which is what the petitioners are seeking below. That is the problem.
And where is that prohibition? That's in the statutes?
It's in the statutes which prevent the use or introduction into evidence in any civil action or in any
So,
court.
so it's not, so are you relying, is this, sorry to keep interrupting, but I have a lot of curiosity about your arguments. Both of which were real brief, but, so, okay, so it sounds like, correct me if I'm conflating two things. Your argument about them, being, about prohibition on the use of the manner in which the appellants wish to use them, which is to show that the experts who may, subsequently testify based on having viewed them. One, argument I think you're saying, which is that violates the statute, because that is by proxy introducing them into evidence.
Yes, Your Honor.
And two is that the general proposition that you're positing, which is that experts shouldn't be testifying about opinions based on admissible evidence. And that was contravening, he talked about the evidence code, and so I would like you to address his counter argument to that. Could you elaborate on those?
Yes, Your Honor. First, the prohibition on use in civil actions has partially been conceded by the petitioners. They have argued below that they recognize that these statutes prevent the introduction into evidence of these records and information about them, but they want this court to find that prohibition is limited solely at trial, which is a distinction that does not exist in the statutes. When the petitioner has relied on this definition of what constitutes evidence, it's relating to this distinction that doesn't exist, saying evidence is only what is submitted at trial. And that really defines the definition of what evidence is. Trial courts conduct evidentiary hearings. Evidence is defined very broadly. And what
Summary
we...
judgment evidence includes deposition answers.
Correct, Your Honor.
So let's say we concede that, you know, we say you're correct, that yes, that prohibition on introduction into evidence at a civil trial, whatever the statute, would prohibit, like in whatever the case is called, the interrogatories, the regala, or would prohibit a deponent being questioned explicitly about the adverse incident report. But they were also did, but doesn't it sound like they were just prohibited from showing them to experts who might later testify? What if an expert saw it and later testified? Why should that be prohibited by the trial?
Your Honor, I think this also gets into what Judge Smith was noting, which was this is not such a blanket prohibition that goes so far outside of the scope of what a trial court can rule, because it's her province to determine how to manage the trial and how to manage discovery. She found that it would be too problematic to undo the die that really would have been cast if we start to show records that the petitioner concedes are inadmissible at trial to experts in the discovery period. And the question is, to what end?
So let's say an expert took the stand and that expert had seen the adverse incident report, but doesn't mention it in his or her testimony.
The problem with that is that the expert could not be cross-examined by the hospital or by any other defendant about what forms the basis for that opinion to really determine and find out.
So you must be relying on the premise that even though that can't be ascertainable because the hospital can't bring it up, but if in part the expert's testimony was based on this inadmissible adverse incident report, that would violate what, the statute?
It would violate the statute, absolutely.
Because that would be by proxy introducing the incident report into evidence?
Yes.
Contrary to the statute's prohibition on introduction of evidence?
Yes, and also case law. This court has held in the Riggins versus, I believe it's Marine Works case, I'll get the full cite to the court. This court has held that, and the standard that was quoted by the petitioner is that yes, experts can review inadmissible records as long as they are the types of records that an expert would normally rely upon to form their opinion. So first, we don't even meet that first part of the test.
We don't know yet. We don't know yet because the expert hasn't had an opportunity yet to be deposed on that issue. So isn't that a bit premature?
In a way, it's premature, but we think that the trial court's prohibition here is appropriate ab initio because she foresees all of the problems on how to undo this down the line. For example, there's a due process problem. If only the petitioner's experts are reviewing these records, our experts can't review them, the other defendants' experts can't review them. They don't have, for example, the co-defendant doctors don't have the same right of access because they weren't patients to get these records, review them.
I'm probably missing something, but you're saying that if they had prevailed in this order, that you're saying the hospital couldn't, I mean, it's the hospital's records.
Yes, Your Honor, but we'd be waiving the privilege if we did that, if we.
I know, but what do you mean you don't have access to the records? They're your records.
I believe I misspoke in that way, but we can't give them to our experts because we would be
Why
then,
can't you give your
we'd be waiving the privilege. We'd be using them in litigation, which is the same problem why the petitioners can't do it. If we were to do that, first, we can't give them to the other co-defendants because they don't have access to these records. It would create a due process problem. Plus, as this court has found, it's not only a question of experts being able to sometimes rely on inadmissible records informing their opinions, but they also can't be used as a conduit to introduce impermissible evidence in an action. And as Judge Morris noted, there's a real problem in trying to extricate these types of records when we're talking about a standard of care opinion. This isn't some sort of extraneous report that relates to something else that occurred at another point. These records are expressly about the care and treatment that was provided in this case. The reason for these statutes and these protections in these records is to allow and further a candid, self-critical process where quality of care provided to patients in hospitals is improved.
I can totally recognize, I think anyone who thinks about the law is sympathetic to the policy objective of these restrictions. You know, you want candid reports. But the Constitution says patients can look at them. And I guess for me, I often dominate these arguments, but I'll try not to. But I just want to tell you what one thing that's on my mind, which is, as I look at 30,000-foot view, the people of Florida said you have access to these records, all right? And that means, just practically speaking, that a patient can find out that the hospital thought they screwed up. And then they can bring an action. And why does that preclude an expert or a lawyer or a consultant of saying, yeah, you know, they did think they, and then independently making a case based on it. In other words, why can't you adduce the expert testimony and you say, well, what did you base, what did you base this on? Well, I based it on this, the doctor's deposition. I based it on all these things. And even though that expert has seen the adverse incident report, why should that be prohibited?
Your Honor, it's prohibited under the statutes because it can't be used in litigation. There's a difference between what the Constitution allows, as Your Honor was explaining. Patients have this right to know. They have a right to have access to records. They have a right to know about them. They also have a right, seeing these records, if they then want to bring suit. That's a patient's right. The problem here is the use in litigation, which the petitioners concede can't come in at trial. And
so back that up. If your point is that they have a right of access, are you conceding that it's silent on the use? And therefore, then if the trial court said, under the amendment that they can't use it, then did the court depart from the essential requirements of the law?
No, Your Honor, we're not conceding that. In fact, that's the express core of our argument, that access is not equated to use. In the Fifth Circuit...
That's what I'm saying. So would you agree that they can use it in litigation outside of trial and admitting it? I mean, I understand the dilemma that an expert is going to have difficulty parsing opinions on what might be inadmissible. But isn't that a problem for the other side to worry about when it happens, and then you come in and you warn them, right? You move to strike. So did the trial court go beyond what it, by finding that they couldn't use it?
No, Your Honor, though, had Your Honor's scenario played out where they showed these records to their experts, absent this court order, and they were questioned about it, what did you rely on? What formed the basis of your opinion? As these records were included, then we absolutely could have moved forward with a motion to strike, and the resulting order, depending on which way it went, could have been before this court or on plenary appeal. That absolutely could have happened. It happened in this way because the petitioners themselves filed a very, to use Your Honor's word, hazy motion, which was 4 paragraphs long, and it asked the court, 5 paragraphs long, and I'm referring to the appendix at pages A41 and 42. That's the underlying motion, which...
That's in the petitioner's petition?
Petitioner's appendix, yes, Your Honor. And in paragraph 4, the plaintiff below said, currently, plaintiff only intends to use the disclosed incident reports with experts and within this instant case. So that was very general and very vague. And the reason why we opposed that is because they were expressly asking to use these records in this case. They went on to state that they wanted to elicit testimony about them, but then also acknowledge that none of this could come in at trial. The Baudouin case addresses this problem and this question of the difference between use and access. And I'll note that the Baudouin case absolutely relied on the Florida Hospital Waterman versus Buster decision. The court examined this exact argument of saying, how can we have a right of access without a right of use? These must go hand in hand. And the court, using proper constitutional interpretation, found that the courts do not have the power to fundamentally change a right or change a word in the Constitution, and that the right of access that is provided is this right to know. And that right has been satisfied. It was satisfied in this case. It was satisfied in the Baudouin case. But that is different.
Counsel for the appellant made an argument that the language was broader than necessary, and I've kind of tried to distill it down to this. It says use and admissibility in body, but the only use at issue was admissibility.
No, Your Honor. While that was one of the uses at issue, there was also testimony at trial, which the plaintiffs had sought to elicit on the stand, and they had been prevented from doing that.
That's conceding that's a conduit for admissibility. So it didn't, and yes, you're right, you know, in the course of this litigation, the appellant has sought to actually, but they haven't sought to admit at trial, they sought to question the deposition. But body cannot necessarily be used as, you know, a slam dunk case that you can't show it to an expert who doesn't mention it on the stand.
Yes, Your Honor. Baudouin does not address experts.
Well, it doesn't address some use short of explicitly, like in Regala, interrogatories, or explicitly deposing a witness and saying, hey, remember that adverse incident report you saw? You know, short of that, it doesn't talk about any kind of use, like showing it to your expert.
It does expressly talk about use. It
Well,
talks about,
use, but the only use at issue was admitting it into trial, like, through some means.
yes, Your Honor, the facts of that case were that they tried to admit them into evidence at trial and to elicit testimony about them. And I'm referring to both of those for a reason, because there are those 2 additional protections, which are an immunity from testimony about this and a protection against admissibility. So that's why I'm describing them as 2 different things, because they're established in the statutes that provide these protections. But the Baudouin court ruling is instructive because they found that what the petitioners there were, the appellants there were asking for, was a right to use. And they said, no, there is no such right to use. There's a right to access which satisfies the purpose of Amendment 7, which is expressly a right to know about adverse medical incidents. Patients in Florida have a right to know about this. They can ask hospitals prospectively. They can ask 3 hospitals, what are your records of adverse medical incidents for hip replacement procedures in the past 5 years, and make an informed decision. They can ask,
What if an expert in the course of, let's say, they were allowed to look at the information, and I know the trial court went ahead and leaped to the original document issue on the exceptions. But let's say there's, in that information, there are original documents that aren't covered under the inadmissibility. I mean, and I know we're talking, you know, what ifs, but isn't that something that an expert then could rely upon if there are original documents?
absolutely, Your
And
Honor.
so how would they know without looking at that information?
Your Honor, the 10 pages that were produced that are the records that are at issue are not original source documents. I appreciate the court's question if you're
You've
saying,
answered my question then, okay, because I saw that the court made that finding and I didn't understand that there's been no objection that some of that might be original source.
the plaintiffs below argued that these protections can't apply to these records because they must be original source documents because they are peer review committee records. I didn't follow that argument below. I argued against it below because the records themselves are 2 incident reports, which are risk management records, which are described in section 395-0197 as created by risk management. The additional records at issue are a letter from a peer review committee member to a doctor, and actual peer review committee meeting minutes. And I believe that the 5th document is a peer review form. They're all documents from peer review committees. As this court has held in the Tarpon Springs Foundation versus White case from 2019, this court discussed the original source exception, which applies to original source records and information that's presented to a peer review committee. So for example, if a peer review committee reviews medical records, that doesn't make the medical records protected under these statutes. They're not privileged, they're not peer review records. The only thing that's protected there is the fact that they were shown to the peer review committee. But of course, an expert later can review those medical records. What the expert can't opine on is the fact that they were also shown to a peer review committee. That's the only part that's out.
You're saying that an expert who's seen them can't apply at all.
Your Honor,
Seems like you're both sides are swinging pretty heavily for the fences.
Your Honor, our argument there is that it could be so damaging that the expert could not unsee and render a clean opinion at trial. And that's what the court was preventing against because
If I could probe that a little bit. So, and I'm going to ask a parallel question. You know, the verbiage, that's not even a word. Verbiage. The verbiage used by both parties is use in litigation. But I don't know where that's necessarily from, because the statutes, are there any statute that says you can't use it in litigation? They talk about you can't testify as to any evidence or other matters produced or presented during the proceedings. I mean, that's pretty, but in other words, maybe you don't understand my question, since you're, okay. I don't know where I was going with that, but I want to know what actually is the prohibition.
yes, I understand the court's question, I believe.
And you've got 1 minute, just so you know.
Thank you, Your Honor. The prohibitions in sections 395-0191, 0193, and 766-101 apply to introduction into evidence in any civil action. And the prohibition on testimony is in any such civil
I
action.
know, but short of testimony and short of introduction, like, I'd like to produce exhibit A, is adverse incident, or short of A, can you talk to me about the adverse incident report, Dr. So-and-so? Where do the statutes prevent the use? In other words, you're going a step further. You got the home run. You got it out, you got an order that, court of appellant, prohibits even showing it to any expert who might later take the stand. Where does that appear?
Your Honor, the-
20 seconds to answer that question.
Thank you. The statutes prevent this use. They prevent it from introduction into evidence. They prevent testimony. That has been interpreted in the courts as use. And to answer Judge Morris's question or note, this shows why this doesn't depart from the essential requirements of law, because the courts have found it and the trial court properly relied upon it, which is why we ask that this court affirms and denies the petition for cert. Thank you, Your Honor.
Thank you very much. You have 5 minutes, sir.
Thank you, Judge Morris. I want to address the last thing first, which is whether there was a departure from the essential requirements of the law. And I just want to direct the court's attention to, it's a case that neither party cited because we didn't really talk about it in the briefs. I think it's Kaklumanos, which is a Florida Supreme Court case on what all that means and how you determine what clearly established law is. But in general, the sources of law can be the Constitution, rules of procedure, judicial decisions, and statutes. And even clearly established law can require some interpretation by the court in determining what that law exactly is. It doesn't need to have something as clear as a judicial decision with the interpretive gloss that we wanted to have before the trial court departs from the essential requirements of the law. And as I said, even if it takes some interpretation, that's allowed in this court's task. And if I'm remembering it correctly, I think it was in Kaklumanos where the Supreme Court did a lot of statutory interpretation, what some of us might think is counterintuitive when we're talking about clearly established law.
Let me ask you this. Did you back yourself into a corner by conceding that this information, 10 pages or whatever amount it is, are inadmissible at trial? Because it seems to me that, if the trial court is looking at this, what value would this then have?
That's where I go back to the distinction between admissibility and the ability of the expert to rely on it. But also, I think, yes, we did say in the trial court that we weren't seeking to admit it. And in some of our papers here, I think we alluded to that as well. But I think that, and even though that's not what we're trying to do right now, I think that's probably not the correct view of the law based on an interpretation of Amendment 7 and an application of the Buster case.
So did you or did you not concede that it was inadmissible at trial?
In the trial court, I think we did make that concession. And that's why it's not an issue today and why we try to factually distinguish value specifically.
You say your distinction is it's not, you're conceding as you must, as your trial must be, that it's inadmissible. I guess if you, well, I don't want to go, but you can, you drew the distinction degrees you are now that a deposition question is not introduction of evidence.
I don't think so. And I want to go back, I think what you may have been discussing earlier with opposing counsel, what exactly that is, what kind of context it is. Summary judgment, right? So you have your summary judgment evidence and you file it with the court, but then parties can object to the trial court's consideration on the basis that it is either inadmissible or could not be reduced to an admissible form at trial. So there are, different stages in the litigation where this issue comes up. I think we may have overstated it in our briefing by limiting it to admissibility at trial, but I don't think that merely asking deposition questions about that implicates it. I think you have to go a step further than in the trial court, in either summary judgment or evidentiary hearing or trial, then try to have it admitted as
Shall be permitted or required to testify. Only that's not a prohibition on asking a deposition question explicitly about the adverse incident report. Because he or she would not be testifying about it, they'd just be answering a deposition question.
I think that's accurate, yes. And that's especially when it comes to experts. I think we would be on good ground with lay witnesses as well, including defendant doctors. But specifically with experts, if we wanted to ask their experts about it, it doesn't get inside kind of the purpose of this, which is protecting the integrity of that process and allowing people to give frank admission or be able to evade these prohibitions by testifying on otherwise privileged or confidential information.
You got 30 seconds.
All right, so just in conclusion, we ask the court to quash the order. It's a very limited relief that we're seeking and allow us to ask questions of witnesses' depositions and also consult with our experts about the amendments of an adverse incident reports. Thank you.
Thank you. Very interesting case. You both did a great job. Thank you.
Thank you.
Next, final case. Jennifer Burke is personal representative of the estate of Juan Alvarez Rodriguez versus Cypress Property in County.